Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. Good morning to everybody. I am so happy to be here today to do this important conference on the issue which we have been dealing with, debating with for many, many years. But still, after many years of hard work, and you will hear about some of that today, there are some issues at the policy level, at the administrative level, which still needs to be talked about, discussed, find recommendations, and then take those recommendations to the provincial and federal government. Both federal and provincial governments representatives from the ministry level do know about our meeting today, and they do know that we are going to be discussing these kind of issues today. So, in a sense, it is important that we all participate into the discussions we are going to have today. And I am very happy to say that, as I said, that we have been working on these issues for many, many years, but about 30 plus years ago, it was mostly people of my age who were discussing this. But now we are at the level that the next generation of professionals, lawyers, activists, and so on and so forth, are stepping forward and taking a leading role in all this. So talking about the leading role, we have with us Amrinder Kaur Diyo. She is going to be the MC for this conference. She is actively involved in the community affairs, and she manages two Gurdwaras presently, Rashtra Gurdwara Sahib and Guru Nanak Darbar Gurdwara in Brampton. So I'm so pleased to invite her, who is going to be the MC for this conference, and looking forward to the discussions and the knowledge and the experience which we will get today, and moving forward to address and resolve some of those issues. Thank you very much.
Good. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. Before we begin, just want to make sure everybody's switched off their phones, put it on silent or quiet mode. And I do believe we have pens and pencils provided for taking notes. If not, we'll have that handed out shortly. Just good afternoon, everyone. We really appreciate the turnout. It's a full room here today. On behalf of the organizing team, Gurdwara Guru Nanak Mission Center, I'd like to warmly welcome everybody. Warmly welcome everybody to Removing Barriers and Moving Towards Acceptance, a conference focused on examining the barriers faced by Sikhs in Canada, namely wearing the turban and Sikh articles of faith in the workplace. My name is Amrinder Kaur Diyo. Most of you might know me as Ruby, and I'll be your MC for today. Today we're going to examine the barriers Sikhs in Canada have faced simply for living their faith openly, understand the real impact those barriers have had on people's lives, and on an honest conversation of what needs to change. Before I walk you through the afternoon, I want to take a moment to acknowledge our distinguished guests. And we are waiting on a few guests to arrive as well, so we'll do those introductions as they do arrive. But firstly, the Honourable Amarjeet Gill, Member of Parliament, Brampton East, Member of a Standing Committee, Justice and Human Rights, and City Councillor Paul Vicente. Like I said, as other dignitaries come through, I will make those announcements. We will begin with a few remarks by the distinguished guests. And the agenda for today, we'll have it in two sessions. The first block will focus on the barriers themselves. Satwinder Singh Gosal will walk us through the legal barriers Sikhs face in wearing their articles of faith, followed by Baljit Singh Kuman on the social and economic impacts of those barriers, and we'll open up the floor for discussion. Our second block will focus on solutions with Bikram Singh Bal on legal and legislative remedies, and Baljit Singh Goprai on strategic alternatives to litigation. And then we'll have our final closing and bring the afternoon to a close together with recommendations and conclusions. It is my honor to welcome everybody to Removing Barriers and Moving Towards Acceptance. If we could have a few remarks from our dignitaries, please welcome Honorable Amarjeet Singh Gill, MP of Brampton, West. Thank you.
Thank you, Amninder. Good afternoon and Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. आज ਆਪਾਂ ਸਾਰੇ ਇੱਥੇ ਇਕੱਠੇ ਹੋਏ ਹੈਗੇ ਆ to discuss about how we can move forward and avoid the barriers that we see for our religious communities. So my name is Amarjeet Gill and I am Member of Parliament for Brampton West. Thank you for the invitation to join you today in bringing together community leaders, legal experts, and policy makers to discuss such an important topic. Canada is built on the principle of freedom, inclusion, and respect for diversity. One of our greatest strengths as a country in our commitment to ensuring that people can practice their faith openly and live according to their beliefs while fully participating in the society. For many Sikhs, Canadian article of faith such as turban and kirpan are not simply symbols. They are deeply meaningful expression of identity, commitment, and spiritual responsibility. At times, workplace policies, safety regulation, and institutional standards have created barriers for individuals who wish to practice their faith openly. Too often, communities have had to challenge these barriers one case at a time, placing the burden on individuals rather than addressing the issue through broader policy solutions. Conversations like the one taking place today are essential because they help us move from reactive solutions towards proactive policies that ensures fairness, consistency, and respect for religious freedom across our institutions. Sikh Canadians have made extraordinary contributions to our country in business, public service, law enforcement, the armed forces, and community leadership. Ensuring that everyone can live according to their beliefs without necessary barriers strengthens not only individual freedoms, but the fabric of our entire society. And I always believe in religious freedom. I always believe in freedom of expression. And I am always in for these kind of discussions which can improve the fabric of our country's society, communities. And we have seen in the past also there was a controversial bill on C9 which impacts our religious freedom and freedom of expression. And I fight for it. And I will continue to fight for those controversial bills. This bill is in Senate, and I will encourage each and every one of you to write to the senators to refuse acceptance of such kind of bill so that we can have religious freedom and freedom of expression intact. Thank you to the Guru Nanak Mission Center and all the organizers for creating this opportunity for dialogue and collaboration. By continuing these conversations and working together, we help ensure that Canada remains a place where people of all faiths, I said all faiths, can live freely, contribute fully, and feel respected. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. Thank you. I do have a certificate of appreciation for Gurdwara Guru Nanak Mission. I would like to invite them to accept it on their behalf.
Thank you very much.
Thank you.
Thank you so much. I would like to now please welcome His Worship Patrick Brown, Mayor of Brampton, and welcome Councillor Paul Vicente to say a few words. Thank you.
Well, first of all, welcome to Brampton City Hall. An honor to have such an august gathering here today. Mr. Bell, thank you for the invitation. Let me just say the topic of discussion today on religious freedom is something that we take very seriously in the city of Brampton. It's a foundational principle in our country, and as Canada's most diverse big city, we really view incursions and diminishments on accommodations for articles of faith really goes against the essence of our country. And it's why Brampton will continue to be fiercely outspoken when we see that happen anywhere in this country. A few years ago, we saw the bill in Quebec, Bill 21, that said you can't wear a turban or any article of faith and be a civil servant, whether it's a police officer, a crown attorney, a teacher, the list goes on. And that bill continues to be, unfortunately, enhanced. And of course, we're having proceedings right now in the Supreme Court challenging the constitutionality of that bill. And it's something we should take seriously because in Canada, we live in a common law system. Precedents matter. We can't have a precedent in this country that you're allowed to trample the rights of religious communities. Because today it may be the turban, tomorrow it may be the hijab or the kippah or the cross. If you allow one religious community to be attacked and diminished and removed from equality, you've normalized that in our country. And that's something that we can never stand for in the country that we love, the country that we're building collectively. It's why the city of Brampton began a campaign to challenge that bill. We donated $100,000 and challenged other cities to do so as well. And the challenge of the WSO, NCCM, and the Canadian Civil Liberties Association to that bill. And I'm proud to say that dozens of cities around the country joined Brampton's call to say, you can't do that in Canada. You cannot trample on the rights of Canadians, because a Canadian is a Canadian is a Canadian. And I thank you for having this conversation today, because really to look at ourselves in the mirror and say, are we doing everything here in Brampton, in Ontario, in Canada to make sure that we live in a community where you never need to hide who you are. You never need to be ashamed of your faith. You can be proud of your faith in this country. So to Mr. Bell and all those involved in this discussion today, I hope it's a fruitful conversation, and know that you can count on your friends at City Hall, myself, Councillor Vicente, and all my council colleagues to be champions of the recommendations that come forth from this conversation today. And once again, welcome to Brampton City Hall. I hope you have a great day. Thank you.
Thank you for those remarks. And now I would like to begin with our first block. Our first presenter is Satwinder Singh Gosal, known to many as Sat. He is a senior partner at RZCD law firm in Peel Region and has spent decades at the forefront of Sikh advocacy in Canada. From landmark legal cases to current work helping launch a permanent Sikh gallery at the Royal Ontario Museum, Sat has dedicated his career to ensuring our community's history and rights are recognized. In 2025, he was awarded the King Charles III Coronation Medal for his contributions to philanthropy and community development. Please welcome Satwinder Singh Gosal.
Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. Before I begin my remarks, I was talking to Manor earlier on this morning. I said, Manor, it's like going back 35 years. We were talking about advocacy and how to educate the community and the general community about the issues facing our full acceptance into society. And we were saying this morning, how have we done? Well, some good, maybe we could have done much more, but we've created the next generation of Sant Sapais, and those Sant Sapais are here. People like Bikram and Balpreet Singh Boparai. You are the warriors committed to social justice that we try to provide all the resources for. So having said that, after reviewing the 5K cases, it is abundantly clear that time and time again, Sikhs were thrown into the lion's den. But they emerged unscathed, their principles and integrity intact. In the process, Sikhs helped to redefine the constitutional values of a modern Canada, a society that is perhaps the most heterogeneous, the most diverse in the history of humanity. In their lament for a lost world, the dominant communities resisted the loss of total power and control. But the adjudicators and judges served as a bulwark, as a restraint against their power. So in this presentation, I will review some of the cases that established, some of the main cases that established the right of Sikhs to wear their articles of faith. Now, in the interest of time, I'll focus on 4 turban cases. At the heart of most of these cases is a collision of interests, a collision of rights, wherein a governmental body or employer attempts to uphold a policy supposedly to minimize harm or to uphold a uniform policy that supposedly commands the respect of the public. Now, I won't have time to get into some of the observations in the discussion, so please feel free to approach me afterwards. I'll give you a copy of my written presentation, but in that presentation, there are important insights into Sikhi. And there are also important insights into our constitutional values made by the judges and adjudicators. Please take the time to read them. They are full of wisdom and they're eloquent. So let's start off with the cases. Very quickly, I'm going to look at the legislation that these cases were built around. I think by now we all understand that the Charter of Rights and Freedoms is the governing legislation of the country. It came about, enforced in 1982. There was considerable opposition to some aspects of the Charter, which we now face the repercussions of. So Section 33 allows certain segments of the Charter to be overridden by levels of government. Unfortunately, Ontario was one of the first governments to override the Charter. The Canadian Human Rights Act, I'll be talking a little bit about this a little later on in the Binder case, Ganel Singh Binder case. If you look at Section 14, that's the main issue in that case, which went all the way to the Supreme Court of Canada. It is not a discriminatory practice if any refusal, exclusion, and the like established by an employer to be based on a bona fide occupational requirement. Those first 4 words, bona fide occupational requirement, required a lot of legal talent over 7 years to define. Ontario Human Rights Code, we'll talk about this in a second. Essentially, there's a prohibition against providing certain services based on prohibited grounds, such as religious faith and creed. So let's go through the cases, the turban cases. And we owe a great debt of ingratitude to the first person, and that's Ishar Singh. In December 1975, Ishar Singh went for an interview with Security Investigation Services Limited, a very large employer of security guards, over 2,400. Ishar Singh was denied employment. His wearing a turban was deemed to offend security's uniform code. The interviewer advised that this uniform code was designed such that it was acceptable to the public and would command respect, although in cross-examinations later on, they had never done any studies as to what would command respect in the eyes of the public. Ishar Singh, advised by John Laskin, his lawyer, who later on went to become a very respected judge in the Ontario Court of Appeal. His father at that time was a Chief Justice of the Supreme Court of Canada. Ishar Singh was also advised by his son, Tishar Singh, who would later become a very prominent lawyer. They challenged the right of security to infringe his rights to wear a turban under Section 5 of the Ontario Human Rights Code, the Equal Treatment Provisions. A board of inquiry, as it's called, that's the tribunal that listens to these cases, was convoked, and the chair of that was a person by the name of Professor Cummings. Now remember that name. We owe him a tremendous debt of gratitude. He was a human rights professor in Alberta. His area of specialty was labor and human rights law. So he chaired the inquiry, and he found very strongly in favor of Ishar Singh. And some of the principles that he established in that particular decision became landmark principles of law, and I'll talk about that in a minute. So the first test was, did Ishar Singh hold his views with sincerity, or was he just being, as the courts would say, frivolous? Was he just really making fun? Based on evidence provided, there were excerpts from Ganda Singh's book on Sikhs and the turban and the articles of faith. Based on that kind of evidence, Professor Cummings decided that Ishar Singh was a deeply religious individual who held his religious conviction with all sincerity. And that's an important first step in all these cases. Does the individual hold his or her views with all sincerity? And that test was later established in a Supreme Court of Canada case, and I won't go into that at this point. Secondly, and what was at issue here was that the security firm was saying, well, we did not intend to discriminate, therefore we shouldn't be found offside of the Ontario Human Rights Code. It's difficult to prove intent. Professor Cummings said, well, hold on. The intent is not relevant. The discriminatory adverse effect, that's what constitutes discrimination. If you can show that this individual has been adversely affected, that's the test I'm looking at. In this case, the adverse effect is quite clear: a loss of religious freedoms and the inability to work in the profession that this person chooses. So he said a policy need not be discriminatory in intent to be discriminatory if in effect it was exclusive of certain target groups. So he went through an extensive analysis, as judges do, of cases in other jurisdictions, such as America, and he looked at the philosophy of the Ontario Human Rights Code. He said, what's the philosophy here? What are we talking about? We're talking about allowing individuals to have the fullest participation in society without the religious freedoms being revoked or curtailed. And lastly, he said, well, look, security. Could you not accommodate Ishar Singh's bona fide religious beliefs without inflicting undue hardship on him? You, security, you, the employer, have the onus. You have the obligation to show us that there's no undue hardship imposed on you, be it financial or otherwise, since you have all the financial information, the financial statements and the like. While this case is going on, Kanal Singh Binder decided to file a complaint with the Canadian Human Rights Tribunal. And this is a fascinating decision, other than the fact that it came out in 1985, my first year in law school, and it was one of the first cases that I reviewed, and that shows how Sikhs have made an impact inadvertently in legal studies. When I was in England, I also came across a Mandla case, so that's another important case I'll touch on briefly. Kanal Singh Binder refused to remove his turban in place of a hard hat or safety helmet in order to comply with CN's work rule, that's Canadian National Railway, that all employees wear a hard hat at a particular place of work. In this case, Kanal Singh Binder was working as a maintenance electrician in a rail yard in Toronto. So based on the facts, as I'll go over it in a minute, there really wasn't any danger to him or anybody else. But CN didn't accommodate him. CN said, sorry, we're not going to allow you to work. We think there's danger to other people and to yourself. Kanal Singh Binder filed a complaint with the Canadian Human Rights Tribunal alleging a violation of Sections 7 and 10 of the Canadian Human Rights Act. Well, a board of inquiry was convoked, and guess who chaired that board of inquiry? Professor Cummings. So he knows the issues. He knows the principles. He knows he now has another chance to advance his principles, legal principles, that is. The Canadian Human Rights Tribunal found in favor of Binder, holding that CN had engaged in discriminatory practice based on adverse discriminatory effect, the same ruling as in the Isher Singh case. That CN's safety hat requirement was not a bona fide occupational requirement. We'll talk about that in a minute. That CN had a duty to accommodate the religious practices of Binder, and that this could be done without undue hardship to CN's business. The tribunal awarded Binder $14,500 for loss of salary and ordered CN to reinstate Binder if he so desired. Now, the case for me has three important elements. First of all, it looks at the scope of review of specialized tribunals, such as human rights tribunals, by upper-level courts. Secondly, it looks at how judges adopt certain tools of interpretation. We call them statutory interpretation rules. There were 10 judges who decided on the facts of this case. 6 decided in favor of CN, 4 in favor of Binder, and yet they were all interpreting the same phrases. And most of that interpretation was that last, if you look at the bottom of the page, what is a bona fide occupational requirement? The case took 7 years to decide, and to the credit of Binder, he had the courage to carry on with the case. Not easy to face litigation every day. The Federal Court of Appeal, on a 2-to-1 decision, said, hey, let's look at the clear language of the Canadian Human Rights Act. Because Binder said you have to evaluate whether there's adverse discriminatory effect, whether I, not everybody else, whether I have faced an adverse discriminatory effect by your disallowing me to wear my turban. So if you look at the language in Section 7 and 10, the judges, Justice Hill said, hey, there's nothing in Section 7 and 10 that requires us to evaluate adverse discriminatory effect. It's sufficient for us to find out that there was no intent to discriminate, therefore we decide in favor of CN. Now, the minority position was a 2-to-1 decision. The minority was, so when you have a minority decision, a judge will give their reasons for the minority, and sometimes they can be persuasive. In this case, the Supreme Court of Canada's minority was very persuasive. So in this particular instance, Justice Ledane, who then later on went to the Supreme Court of Canada, he said, let's look at the facts. Because where is the harm here? Where is the harm? And you'll find this kind of argument in most of these 5K cases. The offensive employer or private organization will overstate the harm. Well, look, if you give this person the right to wear the kirpan, all kinds of violence will be inflicted. Well, where is the evidence for that? Or if, in Baltesh Singh Dhillon's case, if you allow a member of the RCMP to wear a turban, people will remove his turban and strangle him or other people. Well, okay, you can't go on vague speculation as to what could happen. Give us evidence that will happen. So Justice Ledane is saying, let's have a pragmatic approach. We are dealing with the findings of fact of a specialized tribunal. That tribunal historically has been comprised of subject matter experts, in this case, a human rights professor. We're not going to disregard his facts, so let's see what the facts say. Number 1, the risk of head injury to Binder if he wore a turban instead of a hard hat. By the way, can everybody hear me okay? Yeah, okay, good. The risk of head injury to Binder if he wore a turban instead of a hard hat was insignificant or slight, and the risk of electrocution was not of sufficient seriousness that it required to be taken into consideration. Number 2, very important. Furthermore, there is no serious risk of injury to other fellow employees, which is often an argument used by discriminators to say, well, look, I'm trying to protect other people. There was no serious risk of injury to other fellow employees or to the public. Number 3, while there was some evidence of the possibility of electrocution, the employee would have had to be grossly negligent to be electrocuted in the area that Binder was customarily working, in the rail yard. Number 4, the potential increase in cost of workers' compensation to CN was minimal in light of the number of employees that will be wearing the turban and in view of the economic size of the employer. So Justice Ledane saying, where's the harm? There really isn't any harm. The federal court's decision favored CN. That was appealed by Binder's legal team to the Supreme Court of Canada. Now, the decisions of the Supreme Court of Canada are very important because every other court has to respect that decision and the principles in that particular case. So, just like in the federal court where the majority said, well, let's look at a plain meaning of the statute, in this particular case, the Supreme Court of Canada, which comprised of 7 judges, 5 voted in favor of CN, 2 or decided in favor of CN, 2 decided in favor of Binder. They're interpreting the same language. So for the majority, the issue was, what is a bona fide occupational requirement? We're back to those 4 words again. The majority, for them, they said that the bona fide occupational requirement was to be applied as the Act plainly and clearly stated, with respect to a requirement for the occupation, not a requirement limited to an individual. See, Binder argued that even if the requirement, in this case, to wear a hard hat and remove the turban, even if it affected one individual, then you could not use a defense of the bona fide occupational requirement. See, the bona fide occupational requirement was a defense used by employers to justify whatever discrimination there was. So the tribunal had found that with respect to non-Sikhs, the requirement was objectively sound. In comes Chief Justice Dixon in what turns out to be a very important dissent and one that really changed the law in this area. Now, dissents are dissents. At the end of the day, Binder lost, CN won, 5-2. But Chief Justice Dixon says, now wait a minute. We can't use the plain meaning tool of interpretation for interpreting what's at stake here. Let's look at the purpose of this legislation. It uses what's called a purposive approach. What's the purpose of the Canadian Human Rights Act? It's to allow individuals to fulfill their desire to do whatever they want in society if they're able to, consistent with their obligations to other members of society, without an infringement on their individual liberties, in this case, the freedom of religion. So from that perspective, a bona fide occupational requirement is not bona fide if it discriminates against one person. And even if you could use, you being the employer could use a defense, you have to show there's no undue hardship. You have to show that you accommodated the differences at hand. The difference being allowing an individual to wear a turban. Surely there's a place in your place of work that this individual could carry on without wearing a hard hat. That decision, the 5-2 decision, was subsequently, in a very rare instance in the history of the hallowed history of the Supreme Court of Canada, was overturned. A couple of years later, in the Alberta Dairy Pool case, the Supreme Court of Canada said we were wrong when we sided in favor of CN. So Justice Dixon, Chief Justice Dixon's opinion became the law in terms of a bona fide occupational requirement defense could only be valid if you could show that there's undue hardship too. The next case, actually, I find fascinating because it's more or less the issue that's in play in Quebec right now, the principle of laïcité. What should be the ability of an individual who comes from a perspective that he or she wants to wear their articles of faith, can they wear them in public places? In this case, the Shwinder Singh said that was a young student, an observant Sikh, as were his parents. He attended a school, a private school called Bayview Glen, and he wanted the right to wear his turban to school. The parents compromised. We'll let him wear a patka in the school colors. The school said no. We've got this philosophical statement which says that we want to minimize outward differences. So the issue was, does a uniform policy of a private school that prohibits external differences between its pupils violate the Ontario Human Rights Code? Is it permissible to curtail individual religious rights in the interest of minimizing outward differences? More or less the issue in Bill 21. Human rights complaint was filed, and guess who chaired the Board of Inquiry? Anybody? It was Professor Cummings. Now, if you read the decision, Professor Cummings is getting a little ticked off. He's saying, doesn't anybody don't employers, don't human resources people, don't educators, don't you read these decisions? The writing's on the wall. It's been on the wall since 1975. This is, 1988. So clearly he found in favor of the young student, Dashminder Singh Sedar. So this issue is important, this issue of why are we time and time again, as I said earlier on, being thrown to the lion's den, why are people ignoring the legal principles at hand? And we can talk about that in our question and answer discussion, because it's important, because the systemic issues are still there. The deputy ministers, the legislators, the people who are in charge of human resources, are they paying enough attention, or are they still worried about losing total control of power? So Professor Cummings, in terms of coming up with this decision, reviewed the statement of philosophy that was implemented by the school, a philosophical statement which aimed at emphasizing equality among all pupils and in minimizing outward differences. There's a long statement, and in that statement, this is the statement of the school, it says, this outwardness in no way precludes the inalienable right, the fundamental right of the individual to be different. Oh, Professor Cummings said, oh, really? He says, and I quote, if a Sikh student is denied the right to wear long hair and a turban in the pursuit of the promotion of sameness, then clearly there is no honoring of differences, and clearly the inalienable right of the individual to be different, as quoted in the philosophy statement, is a sham. So he's losing his patience. He's saying, come on, guys, you don't get it. Why are you wasting our time? Why are you wasting the taxpayers' money? You need to understand this stuff. And in making his decision, he reviewed jurisprudence from other countries. In this case, there's a very famous case going on at that time. It had just been decided. It's a case that I studied when I was finishing my law studies in London, England. It's a Mandla Seva Singh case. It's a decision of the House of Lords. Similar facts, private school boy not allowed to wear his turban in this case, went all the way to the highest level. And in that particular case, I'm not going to go through it, but it's fascinating. There is a wonderful clarification of what a Qaum is. So to qualify in England for race, it was called the Race Relations Act, to qualify for the equivalent of Ontario Human Rights Code relief, you have to show you're part of a race. Take a look at that case, you'll find it fascinating. So I'm coming on to my last case here. I think you're all still with me, that's good. We're looking at the late 1980s now. The promotion of tolerance for individual liberties is certainly well respected in the courts and by adjudicators. The promotion of individual rights to be different is gaining judicial acceptance. However, public acceptance was still very, very subdued, to put it mildly. In February 1990, the Chief Commissioner of the Federal Human Rights Commission lamented the unprecedented increase of racism in Canada. A report in the Toronto Star at the same time concluded that 2 out of 3 Canadians admitted to being a bigot. So into the fray jumps Baltej Singh Dhillon. Baltej Singh Dhillon, born and raised in Malaysia, came to Canada, wanted to be a member of the RCMP. He qualified with all the tests, but he could not remove his turban, would not remove his turban. It was a violation of his principles. Now, the RCMP, since 1982, when the Binder case first started, they were contemplating changing their regulations, but they knew that this was going to be a political minefield, especially out in Alberta. Because in the mind's eye of people in Alberta, Canada is associated with the RCMP officer wearing a wide-brimmed Stetson. So they moved slowly. Finally, with some courage and a lot of push by people from the community, in April 1989, Commissioner Inkster, who's head of the RCMP, issued a bulletin to change the RCMP manual. Members who practice the Sikh religion were permitted to wear an RCMP-issued turban, providing it concealed the hair and was neat. They were allowed to wear under the uniform a small kirpan, having a maximum length of 3.5 inches. Importantly, exemptions from the uniform policy would also be permitted to persons on a similar basis to those granted to Sikhs if they could prove the need for the exemption on religious grounds. So ultimately, in March 1990, the government of Brian Mulroney legally enacted these changes. I remember this very well. I remember discussing the principles, legal principles, with a young Balbinder Singh Shergill, who represented the WSO, who did a remarkable job in presenting briefs and have done consistently in these kind of cases. This is when I, as a young man, became actively involved in advocacy groups who were non-Sikh, because it's one thing to have Sikhs on side, it's more important to have other groups on side. And so this galvanized us all. We were shocked by the public insult of not only Sikhs, but of all minority groups, especially from out west. There were offensive buttons, there were petitions in the number of 200,000 presented to members of parliament saying, we will not abide by the change in uniform policy, which allowed women RCMP officers to wear trousers and turban Sikhs to become members of the RCMP. The plaintiffs in this case were wives of ex-RCMP officers and ex-RCMP officers. They went to challenge the regulations based on the Charter of Rights. Now, this is a case of how you lose your arguments. And as I reread this case for maybe the 15th time, I can literally feel Madam Justice Reed rolling her eyes saying, why is this case even in front of me? Just like Professor Cummings, why is this case even in front of me? The plaintiffs don't really have much of an argument, but she patiently went through the issues. So the main points of contention were sections 2 of the Charter. So the plaintiff said, we're denied our freedom of conscience and religion. Section 7, everyone has a right to life, liberty, and security of the person, and right not to be deprived thereof except in accordance with principles of fundamental justice. If somebody's going to arrest me, if a police officer is going to arrest me, it better be in accordance with principles of fundamental justice. Section 15, every individual is equal before and under the law and the right of equal protection. So what did Justice Reed make of these arguments? Madam Justice Reed said, okay, let's go through the very first argument, Section 2A. Basically, the plaintiffs are saying that by allowing an RCMP officer to wear a turban, the government is actually preferring one religion over another. They're almost indoctrinating people about this religion. She said, first of all, I don't think, realistically, anybody can say that Canada is not a secular country. In fact, just recently we removed Christian elements from the House of Commons prayers in the morning. Secondly, there really is not the principle of state neutrality in Canada. Never has been. Canada was founded on allowing certain religious accommodations. In Quebec, the right to have Protestant schools. In Ontario, the right to have Catholic schools. There never was a separation. Now, what's really going on here, she's saying? If an RCMP officer wearing a turban meets a member of the public, is the RCMP officer going to prevent that individual from carrying on practicing his or her religion, or coerce that person to become a Sikh? She basically very politely said, well, that's a silly argument. And the next one was even sillier, she said, and that is Section 7. The argument here was, well, by allowing an individual with a turban...
Sorry.
As to Section 7, Antigua, shall I go back 10 minutes? No? Okay. I don't think they can wait 10 minutes. I'm almost done here. As to Section 7, the argument was that if I'm going to be somehow approached by an RCMP officer wearing a turban, then I think there's an apprehension of bias. So Madam Justice Reed said, I don't really think that a Hindu Canadian or a Muslim Canadian, if you could at all determine that when you first come across them, if you're an RCMP officer, is going to feel that they're being discriminated against by an RCMP officer wearing a turban. It doesn't make any sense, she was saying. The evidence in support of this argument was at best vague and speculative. So in all these cases, there's an allegation of some kind of fantastic harm being committed. Well, show us the proof of that. Madam Justice Reed said there was no proof of that. She said it could just as easily be assumed that some people will not view the turban as a religious marker, but as a cultural one. Or they may see it as a benign or as an indication of integrity and strength. Now finally, as to Section 15, the argument here was that other people wouldn't be given the same exemption as Sikhs. Again, Madam Justice Reed said, well, hold on. When the regulations were enacted or promulgated, as they're called, there was specific allowance for other groups to also ask for exemptions if they wanted, but nobody has approached us. But if they did, they would also be allowed to make their case to see if they're entitled to exemptions. Then she flips the argument on its head based on presentations made by interveners. Interveners are public interest groups, WSO has often been an intervener, that are allowed to participate in a legal argument. So the Alberta Civil Liberties Commission said, what's really at issue here? The issue is not that there be discrimination against other groups that might come up in the future. The issue is discrimination against Sikhs now. And she comes up with this remarkable quote from Justice Frankfurter, a respected U.S. Supreme Court Justice of 1950. And the quote is this: "It was a wise man who said there is no greater inequality than the equal treatment of unequals. There is no greater inequality than the equal treatment of unequals." And in this case, the unequals were Sikhs. It's a lovely decision. Please, if you have the time, read it. It's full of insights into Sikhi. Madam Justice Reed was presented, as in all these cases, by expert evidence. There were people consistently providing expert evidence. Spellman, Hugh MacLeod. In this particular case, Gyan Singh Sandhu, there was evidence that in 1857, as Sikhs became part of the British India Army, they were required, all Sikhs were required to become Khalsa Sikhs. Why? Because they commanded respect. And here we are, in this case, at this time, when over 200,000 people in Alberta were saying, we can never respect an individual wearing a turban in the RCMP. I just want to wrap up. I think I've exceeded my 15 minutes, 10 minutes ago, by some concluding comments. Many of these cases advance important legal principles in the area of human rights and labor law and employment law. Legal obstacles were considerable, expensive, and emotionally exhausting. But we see the effects in the Binder case, once and for all, the understanding of law as it related to what's a bona fide occupational requirement, the duty to accommodate it, cemented in law thanks largely to first Ishwar Singh and then Karnail Singh Binder, and Professor Cummings had no small role in that important change in the law. Thus, from that point onwards, employers needed to carefully examine workplace requirements and culture to ensure inclusion. There were considerable emotional barriers, let's not forget those. Karnail Singh Binder had to go through 7 years to see if a decision would go in his favor, and it didn't until well after. I represented Pradeep Singh Nagra. I remember the insults and the death threats that he faced. I was there when he boxed a very, very hostile crowd. I remember Baldev Singh Dillon during the time that he had to face public humiliation, yet they remained steadfast. The resolve in having their values and identity appreciated, respected, and accepted was unwavering. To their great credit, they did not compromise their religious beliefs. Inadvertently, they provoked the great Canadian debate about identity and the interplay of race, religion, culture, and immigration during this browning of Canada. Except the debate now was not amongst the dominant groups, the Anglo-Celtic and French groups and indigenous groups. Into that debate came people who had markedly different religious practices that were supposed to be protected by the Charter. The Charter was designed to protect their rights. These cases served to educate administrators and executives at large organizations, whether in the private sector, CN, or in governmental agencies. The judges and adjudicators generally got it right. The public, not so much. Their unfiltered biases came through. Taxpayers' dollars were needlessly squandered. Community groups fared better. Originally, groups like the McAuliffe Institute, the Ontario Council of Sikhs, the Centennial Foundation, the Sikh Foundation, and ultimately, to their great credit, the WSO, learned how to present powerful briefs to courts to change minds, legal minds, and also to various other institutions that had to be influenced, the bureaucrats, the politicians. As a result, diversity, equity, and inclusion initiatives were mandated in the 1990s. Some glass ceilings were broken, although many still remain. Thank you.
Thank you, Sat. Our second presenter is Baljit Singh Kumman, a community activist, author, and IT professional with over 27 years of experience. Baljit co-founded the Canadian Sikh Association, which played a leading role in securing the motorcycle helmet exemption for turban-wearing Sikhs in Ontario. He's also the founder for Sikhs for Autism and the creator of the Mustard Flower Campaign, a symbol for Sikh genocide awareness. Please welcome Baljit Singh Kumman.
Thank you. Yep, I will. Good afternoon, everyone. Thank you so much for coming, and thank you to the organization for having me here speak. I will be looking at the social and economical impacts for the employment barriers for Sikh community. I won't be getting into the legal aspect of things, but more social and financial aspect, how that impacts the community. Let me figure out how this works here. All right, I got it. So social impact we will explore that first, then we'll move on to economic impact, and then I will talk a little bit about the broader aspects and the broader impact of the employment barriers. So just a few stats before we get deep into the presentation. There are approximately 2.1% Sikhs in Canada. So this stats is from Stats Canada, Census 2021. About 800,000 we are across Canada, and 39% of those Sikhs are in the city of Brampton. So that is approximately very close to 200,000. This number is from 2021, and I'm sure the number has changed over the years, in the last 4 or 5 years, and my perception is that it has gone up. So it really impacts us because in Ontario, in Brampton, the concentration of the Sikh community is majority in Ontario and British Columbia, and obviously it is spreading in other provinces as well. So first, let's have a look at the social impacts of visible faith and discrimination. So with the Sikh community, a turban Sikh or a Khalsa Sikh, a baptized Sikh, the article of faiths are very visual. The 5 Ks, the Panj Kakar, at least 2 or 3 of them are very visible. The turban, the kada, and the kirpan. So you're able to see them while a turban Sikh is out in the community, and it is very visual that catches your eye. In many cultures and religions, those symbols, those articles of faith are not too visible out there, they're not in the face. So the identification is the right way, it's right in their face. When social exclusion and bullying happens because of that article of faith being so visual and so different in a nation where Sikh community is an immigrant, is a migrant community. Last 100 or so years we've been here, and in last 20 years, there's another stats from Stats Canada that in last 20 years, Sikh community in Canada have increased by 130%. So that's a huge number, even though yes, we are 2.1%, but that expansion has happened a lot in 80s, 90s, and very recently in 2000s. So the number has gone up, the visibility has gone up. So what that does when there is social exclusion, there is bullying, hate crime, that impacts the self-esteem, not only just the individual, but the community. And I'm going to try to talk about the community perspective more, because individually and collaboratively, it is the self-esteem of the community which is broken. The sense of belonging decreases a little. You start thinking that, do I really belong here? Is this place for me? Those are the questions that an individual will ask. Those are the questions that the families discuss. Those are the questions that the community discuss, and that's why we are here today discussing this. Not only that, in many cases, and you see this in the media as well, people start avoiding public spaces out of fear that somebody may say something which is negative to me, out of fear of any hate crimes, and that we have seen in last decade or so, that multiple incidents which people are fearful to go out. Secondly, looking at the impact of discrimination laws, they are very visible, and if we talk about Bill 21 in Quebec, which has been mentioned in the last presentation as well, where religious communities are being restricted, Sikhs are being restricted from wearing a turban or a kirban if they want a public service. That is another issue that is restricting you from the employment that you may qualify, or that's something you want to do as a career. The last point on this slide I want to discuss is the media misrepresentation and what it does to a community and to an individual. It puts, and when I talk about media, not only just mainstream media, TV or newspapers, I'm also talking about social media, because that's where the majority of Canadians now are getting their news. That's the first thing you do in the morning. Go on the Facebook, go on the X, or go on Instagram or TikTok. That's where people are catching up. People are not spending as much time on a mainstream media, which may have done their background checks before reporting. So a lot of misrepresentation, lot of people out there which are just saying things to get the likes and followings, and people are buying into it. There are too many examples out there that we can talk about that is happening. What that have done is that it have put Sikh community in a constant navigation mode. There are pressures, and there is a constant navigation through those pressures while practicing their faith. They want to maintain to practice their faith the way they want it, but at the same time want the same opportunities which they deserve, which they qualify for. And when they don't see it, that is a negative impact on their career path. What all this does is it creates a stereotype, multiple stereotypes, and that stereotypes are fed into our brains as a community at large. And out of that community at large, there are a lot of employers, a lot of hiring managers who are also listening to this same media misrepresentation and absorbing that stereotypes which are being thrown at them. And when they are listening to this multiple times again and again, it kind of becomes their truth. Those are the stereotypes they walk around, and when they look at a turban Sikh, those are the first thoughts which come to it, because media is very powerful. The imaging is very powerful. You look at that, and that's what imprints on your mind. So, I want to talk a little bit about the intergenerational impacts. I think this is extremely important. So educational, economical, and social aspect of it. So I will do it very quickly. Family support. When an individual encounters a barrier to employment and unable to get the job that they deserve or that they want or that they qualify for. They're not able to get that. That impacts the money flowing in to that individual and to that family. They may not be able to support the education of their children. That is a direct impact on the next generation of Sikh community. Are they able to help their children get the university college degrees, which are extremely expensive now? And navigating the impact on generational wealth building. So how communities do well in long run, in 2, 3, 4 generations, they build their own generational wealth, which is passed on. May it be a real estate, may it be money, may it be anything else, stocks, bonds, any economical, material or finances that is passed on. But if they're gonna not able to get the jobs they want, and they're gonna just live hand to mouth and earn and pay the bills, there is nothing to hand over to the next generation. And next generation is unable to get the education they should get in Canada, they go in the same cycle. So it's a generational impact. And the social standing, what I'm trying to say there is that people may start off well, and the social status is high. They're migrating here, they're not able to actually do what they thought they are able to do here. And the reason being barriers to the employment because of their faith, their status drops. Their finances drops, they're not able to maintain the lifestyle, the standard of living that they had. That is a negative aspect of it. It is a negative impact from the Canadian perspective. I know people which are, there was a time when there was no question about I want to migrate to Canada, excellent. But there is a time now when people are debating, should I be migrating to Canada? Because they are looking at these stats and they're talking to people. As I said, the immigration has gone up, the world goes around. So let's have a look at the economical side of it. I have spoken a little bit already on this. Hiring discrimination excludes the talent. So I mentioned before that the perception, the stereotypes is trickling down from top down to the community. And when I say community, employers, hiring managers. So now the hiring manager is in an interview with a turban Sikh or a Sikh whose article of faith are visible. The stereotypes right there, they start taking, they start thinking, judging happens automatically. So it's good that we have the legal framework. And also Satwinder Gosal talked about Ontario Human Rights Commission and the cases and the decisions, and again they're asking why these cases are here. Again, these hiring managers are there, but they are not reading those decisions. They are not reading what Ontario Human Rights Commission is saying about it. They are going by the stereotyping in their mind, which is set, and that is the key part. We can have the legal framework there, but how do we take those decisions, that information down to the level of a hiring manager and human resources departments across the institutions, that they are fully educated about it and they don't go by their stereotypes, but they understand what the laws and what the human rights says. That is a big challenge. What happens at that time if you are not getting that job? That's a loss of talent, the potential talent that could have created much more potential out there, and the loss of potential wealth for that individual and that family. Underemployment and economical insecurity, this is where individuals who take the jobs which they are underqualified for. They should be doing a job that they want, which they qualify, but now they are not able to get it because there are these barriers, stereotypes, people not understanding these decisions by the courts, and now they will go do whatever they can. What that does is, many communities, it creates a clustering. And what I mean is, a community will be pushed towards a certain trade or a certain kind of jobs, and usually these jobs are nobody wants to do, and suddenly that's what is available to them. And they shouldn't be doing that. They are qualified for other jobs which are available, but there is an obstacle because of their faith, and they will do whatever they can to survive and go from there. Reduced income security and limited career progress. That's where it goes. Next slide is, for me, it's very important. A lot of my work in the last 11 years have been on neurodiversity, disability rights, and autism. So I've spent a lot of time working on that with schools and universities and parents and individuals who are autistic and their employment issues and incentives by the government for the corporations to hire them. So I thought it is very important to put this here and bring this up, that specifically Sikh women, people with ability challenges, and older adults who are still seeking, they're still seeking employment, they deal with the dual barriers now. They're wearing the visible article of faith, but now there is a gender, and then there is ability challenges, and then neurodiversity comes in play. And that is an added channel. And our managers, to my experience, and I have dealt with few of these, I have been on a hiring board myself, I have interviewed people, and there are issues where these things become obstacles, and hiring managers are not fully trained or knowledgeable how to get around that, how to go about doing that. So that is another issue. So looking at the wider effects of employment barrier, social isolation and mental health, inadequate workplace accommodations and discrimination and emotional impact. With social isolation, access to health services, when you are not getting what you need, the financial pressure, the economical pressures, the families not doing well, living hand to mouth, that is creating a stress, anxiety, and which becomes a mental health issue. A lot of these families in a stage where they're not even aware of what kind of health services are available to them. And I get a lot of phone calls on this from the parents of autistic children, of other individuals in the community who are dealing with or have a member in the family dealing with mental health issues. They are not fully aware where to go, how to access the health system, which agency can they go to. There is a lot out there, but do the community know about that? Is there a mechanism to bring that information to those individuals and connect to the agencies? And that's what I do. I do a lot of connecting. Hey, you can go here, this is the where. You know, somebody needed a wheelchair, where can I get a wheelchair? I connected with this organization who can get you a free wheelchair because they couldn't afford it for their child. It took them 12 months to get a wheelchair for a child who couldn't walk. And this is happening here. So there are multiple aspects which these families are dealing with. Inadequate accommodations, and in the last presentation it was mentioned, and I will mention it too. When individual have to challenge, that responsibility should be on the employers and the governments and the lawmakers. That why do an individual again and again and again in silos must challenge the system to get a right which is already enshrined in the Charter of Rights under Human Rights Commissions, under all these decisions done in the cases. Why do they have to keep doing that, wasting the resource of an individual but a community resource? So that onus should be put on the employers to proactively work that out. And I think human resource area is the main area where it maybe should all start. Maybe the human resources areas should be diversified, where it is represented not just the mainstream, but various cultures, religious cultures, communities. When the hiring and the human resources are discussed, these various voices are on the table and they say, hey, wait, this is not right, this impacts these communities and we need to discuss that. And I would just like to say that healthy community is equal to healthy Canada. So that if we want Canada to be healthy, the communities need to be healthy. And if the economical part of the community is broken, then we are in trouble. So this, I'm not going to go through this. This is all the things that I have spoken so far. I've just put it in a visual aspect so you guys can see it from left to right. Religious discrimination and what it does for social impact and economic impact. You can have a quick look at it. The last one, gender plus ability plus neurodiversity plus racial intersectionality, which is very little discussed in our community at least. And this is a huge gap when it comes to the careers, employment and job equity. So that is very important, and they end up having the compounded risks. So it adds up, it stacks up. So I'm going to try to stay within the time, and I think this is the last slide. Moving forward and acceptance. So this could be as a suggestions or recommendations that I have. Development of religious and cultural competencies. This is where we are shaping the public attitude and creating cultural intelligence. As I said, we can have the laws, we can have all the legalities, we can have all the decisions by the court system, we can have all the human rights speaking about it. But if that has not trickled down where the rubber hits the ground, things are not going to change. The court cases are no good if they're on the shelf, but the court cases needs to be at the human resource level where the hiring is happening. The decisions need to be there. People in human resources need to be extremely educated when they're doing this hiring. Religious, cultural integration at policy level. Again, I already spoke about it, that we need diverse representation on the hiring manager's table. And last point, national employment inclusion strategy. So every province, every territory, every city have their own little separate policies or laws. There need to be a blanket, national-wide, some kind of a coordination where we all understand, all human resources, all corporations, all institutions, all government institutions understand that this is the minimum standard that we have to hold ourselves, not at a local level that we choose to decide what policies we can make, and then individual person have to challenge them, go up at that level, and then come down with their decision. That's a wastage of time and resources. And I think that with that and my discussion here, and hopefully you guys have got something good out of it. Thank you so much.
Thank you to both speakers. In the interest of time, we did have discussion allocated for right now. I would ask for those of you that have any questions or comments to just hold on. We'll do the discussion jointly with the discussion session we've allocated for the last bit. Sorry.
We actually have to leave, but we would like to say one thing, if we could.
Yes. Yes, please. Active it.
Thank you for inviting us today. We're here from the Peel Law Association. We operate out of the Brampton Courthouse. Just two things I'd like to say today. Number one, I think you'd be very, very encouraged to see that the cohorts of new lawyers who are coming up several times a year, getting accredited to practice law in the province of Ontario, there's a very significant proportion of them who are young Sikhs. So you're being very well represented in the legal system. However, one of the reasons we came out today is that there is a tremendous and terrible shortage of court interpreters. We do not have enough people who speak Punjabi at the courthouse, which means court cases are getting postponed. For some of the court cases, we need 2 translators or interpreters in the courtroom at all times, and we don't even have 1. So it's contract work that's available through the Ministry of the Attorney General, $60 to $70 an hour. It's quite lucrative. So if you know any people who are looking for temporary, part-time, casual work, meaningful work, providing access to justice for your community, I would strongly encourage you to spread the word. And I would like to share some more information with you afterwards. Maybe you could help us get voices for your people in the courtroom. Thank you.
Thank you. That's very important information for the community, and we'll definitely share that with everybody. Thank you. And we do have the Honorable Ruby Sahota that's just joined us. So what we'll do is give a few moments for her to come give her remarks, and then we'll proceed with the second half of the session. So the Honorable Ruby Sahota, Member of Parliament, Brampton North Caledon, Secretary of State Combating Crime. Thank you.
Thank you. Good afternoon. Vahguruji Ka Khalsa, Vahguruji Ki Fateh. I don't have any planned remarks. I didn't know what to expect out of today's event, but I'm very pleased to see so many faces here attending today's event, so many experts in different fields that can better inform us about how to move forward with accommodation and making sure that all Canadians feel included in all workplaces, in all walks of life, and in all provinces. I mean, I guess the elephant in the room to some degree is the case on the notwithstanding clause before the Supreme Court right now, which was started because of Bill 21 in Quebec. And I know that the WSO, well, it's good to see you here, has been as an intervener, as an appellant of the case. Okay, as an appellant of the case, and of course the Government of Canada has also made submissions or making submissions in that. I've been getting some updates. I wish I could have followed it in live time, but I have been following somewhat over the weekend, and will look to see what all of the different arguments that have been submitted have been. Ontario has submitted against the province of Ontario for different reasons because of the issues that they're facing on the notwithstanding clause in terms of the legislation that Ontario has put forward. So I guess what I will say is that this is going to be, and this is the most long-awaited Supreme Court case in a long time, and the Government of Canada is supportive of the position not to be abusing and overusing the notwithstanding clause, especially when it concerns individuals' charter rights. Our government and our party has always been a strong defender of the Charter of Rights and Freedoms. We will continue to defend individual rights under that charter, religious rights under the charter. And so I look forward to standing with the community in that regard and on all of these issues. So we'll look forward to seeing what comes out of today's seminar and what we can learn and where we can better have legislative changes if needed to help provide the reassurances that are needed in many cases. So I know that WSO has done a good job in the past at bringing up the issue, that many people are still having to face many barriers and challenges when bringing individual cases to tribunals. Hopefully this case will bring more clarity as to where things stand, but if clarity is not brought, then the government will be looking at making sure that things are made more clear through legislation in the coming time. So thank you for having me here, and I'm always available to have conversations and discussions on any issue that is important to anyone in this room or anyone that you know. I want to thank Guru Nanak Mission, Manohar Bal especially, and your whole team for holding an event like this today. As politicians, we go to many events, but not all events are equal. I would say an event of this caliber to discuss issues of the community and to come up with recommendations and results at the end of it is time well spent. And I'm glad that Guru Nanak Mission is taking a lead on these issues and putting so much effort and work into representing the Sikh community and representing all Canadians in one way. The Sikh community has been known to fight many challenges that also ends up helping many other communities along the way as well. So you've always been leaders in that front, and I benefit from your example and your leadership as well. So I have a token of appreciation. Mr. Bala, if you could come up, and anyone else that you'd like to invite up as well.
Thank you, Ruby. Moving on to the second block of our conference, we'll move to the next set of presenters. Our next presenter is Bikram Singh Ball, a commercial litigation lawyer and a partner at... Pause on what I just said. I would like to welcome Hardeep Singh, Deputy Mayor, and Councillor Short. Thank you. Please come say a few words.
Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh. It's an absolute pleasure to be here, and I want to thank Gurdwara Guru Nanak Mission Center and Jiri's community members ikkathe karte sanstha. I see Sukhmani Haven, I see Drug Awareness Society, I saw HOA in the back, I see Sikhs for Autism WSO. It's great to see everybody come on one platform to talk about issues affecting our community. And when we work together, when we have dialogue and talk amongst each other and see what the best way forward to move is with unity and ekta, that's very important. So thank you to Gurdwara Guru Nanak Mission Center, thank you to the committee, thank you to all the Sevadars, and from the city of Brampton, we'll be there to support you along the way. Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh.
Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. It is a pleasure to be here today and to see the incredible work that you're doing. Kudos to the team behind it, to formalize all of this in a document, this discussion. ਕਿਉਂਕਿ ਅਕਸਰ ਜਿਹੜੀ ਇਹ ਡਿਸਕਸ਼ਨ ਹੈਗੀ ਆ ਸਾਡੇ ਭਾਈਚਾਰੇ ਦੇ ਵਿੱਚ ਸਾਡੇ ਘਰਾਂ ਦੇ ਵਿੱਚ ਸਾਡੀ ਕਮਿਊਨਿਟੀ ਦੇ ਵਿੱਚ ਜ਼ਰੂਰ ਹੁੰਦੀ ਹੈ but we don't see that formalized in such a way here, so thank you for putting it all together. Despite we were having a discussion in the back in Brampton, we may think that we don't face these challenges, or sometimes people from outside of Canada think we don't face these challenges within Canada, but we absolutely do. And what I like about the theme of the discussion here is moving towards acceptance and not on just exceptions or exemptions. I know WSO does a lot of legal work around this, but then you look at something like Bill 21 again that happens, and the fight that it does, that is at Supreme Court of Canada. You see how important all of this work is. Here at the City of Brampton as well, we face the similar challenges. When I go to businesses on business tours, often people are surprised to see me there because now they don't know if they can let me into the facility. Do I have to wear a beard net?
How will I get safety goggles on? How do I have to get any of that? And you can see senior management panicking for 30 minutes trying to find something that I could wear so I could walk into the facility. But I have the privilege that I'm an elected official and they have to do something for me. But the reality is then what happens to workers, what happens to our residents or anybody else. So I'm very glad to see all of this work happening here. Just a big congratulations to the team. Thank you for formalizing this. I know all eyes are always on Brampton and what happens here. So I'm very proud that our local Gurdwara is championing this as well. So once again, thank you for all the work. Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh.
Thank you. So we're good to move on. So our next presenter is Bikram Singh Bal, a commercial litigation lawyer and partner at FDH Lawyers. He has been practicing law in Ontario since 2015 and has spent the past decade working with advocacy groups and legislators at all levels of government to find long-term policy-based solutions to the barriers faced by Sikhs in Canada. Welcome.
Good afternoon, everyone. Thank you for the introduction by Ruby. We've heard a lot today already about the history of court cases in Canada, the experiences that Sikhs have faced throughout the last many decades, largely perhaps during the course of when a lot of us here were very young or perhaps not even born yet. But the next phase of our discussion is going to be focused on how do we move forward in a more lasting process, in a more lasting manner, so that hopefully 30 years from now, I'm not here having the same conversation with my future children. Okay, that's the goal that we're trying to achieve with this conference. And so my remarks will focus on legislative remedies to address the inequalities faced by Sikhs in Canada and propose some practical steps with historical justifications as to why they are practical. Primarily the case for legislative action, either through legislation or regulation, is properly set out by the experience faced by Sikhs in Canada, as I said, in the last many decades. This juxtaposition and this issue is, I think, most importantly highlighted by the experience that the Sikhs in Ontario faced when seeking a motorcycle helmet exemption for the helmet laws here in Ontario. So in light of that, I begin with a simple proposition. In a democratic, pluralistic society, the most stable and meaningful way to honor diverse identities is to write that respect into the law, and then operate that law with clear and workable regulations. When it comes to the full recognition, including the turban and articles of faith, legislative action supported by thoughtful regulatory design is not just one option among many. It is the preferred and proven path to durable society-wide inclusion. Indeed, this action through regulations is the most effective and durable, and such recognition can proactively accommodate religious practice, resolve recurring conflicts across systems, and provide clear, uniform direction to public bodies and the broader society. The historical record demonstrates that whereas courts face inherent limits in balancing competing interests on a case-by-case basis, legislatures can and have delivered principled, comprehensive recognition that aligns with Canada's multicultural commitments. Indeed, this action is capable of addressing the complex issues of balancing cultural issues, safety, administrative considerations, and to holistically and properly put them into one method of solution rather than going through repeated litigation. And so as I mentioned, I want to use just a small example that I know likely a lot of us here are familiar with. As we know, earlier in the 2010s, a member of our community challenged the constitutionality of the Highway Traffic Act on the basis that he should be allowed to wear a turban while riding a motorcycle. Now, In 2018, we achieved that recognition, but the reality is that it took over 30 years to get to that point. And so in Ontario, the reality is that the reconciliation of these mandatory helmet laws was a long path that justifies the reason why regulations and legislative change is the most important way to go about it. So in that case, when that constitutional challenge took place, and I know that in the appeal, the WSO was involved very actively as well in advocating for this constitutional challenge. What happened is that at the time of the constitutional application, unfortunately, we were not successful. However, most importantly, in 2018, Justice Blacklock, I apologize, wrote in their decision that while Mr. Badesha would not be successful in his constitutional challenge, Justice Blacklock mentioned at paragraph 99 that I want to emphasize again, the outcome of this case turned on what I determined was or was not required as a matter of constitutional law and the Ontario Human Rights Code. What the province may choose to do in this area as a matter of policy now or in the future, of course, remains a matter for the legislature. So ultimately, a very clear indication that even courts, when faced with their inherent limits, still look to the legislature to come to some sort of a solution when it is necessary. And so ultimately, when courts cannot get us to that conclusion, that is where policy solutions succeed. And that is, in fact, what our history in Canada has demonstrated. The reason why that is there's a community path as to how we achieve that motorcycle recognition. After sustained cross-party community engagement, we obtained that recognition and that necessary meaning in our community. And the deeper meaning for that, as far as I think, is that regulatory decision translated values and beliefs into enforceable everyday rules. It reflected a society now that choosing through its democratic institutions to make room for that consciousness that we all believe. Ultimately, this clarity that can be provided through a wide array of forums, whether that's transportation, employment, security issues, any other forum that are public-facing, in the instance of Sikhs, these legislative instruments can provide clarity and precision to regulators, police, employers, the public, as to how the Sikh articles of faith, including the turban, are to be accepted in society and including in the workplace. And so I want to very briefly, on a very high level, just explain what the legislative process looks like and what the regulatory process looks like. And I'll focus largely on the federal process. The provincial process is slightly different, and each province may have its own unique features. But from a federal standpoint, the legislation, any sort of law, is a written law that provides the rules of conduct. To become a law, the legislation must be approved by Parliament. Any legislation is introduced into a parliament or a legislature in the form of a bill, which provides the basis to either amend, repeal, or create new laws. Canada's legislature, the parliament, involves all three houses, so all three parts of the parliament, which is the House of Commons, the Senate, and then ultimately the monarchy as giving royal assent. Now, these three parts can be summarized in this manner. First, the policy concept has to exist. It has to move through cabinet for approval. Bills are drafted and presented in the House of Commons. Committee meetings may take place to discuss any changes or amendments or necessary modifications to the proposed bills. And then as that proceeds, the House of Commons and the Senate, and then ultimately by royal assent, the monarchy signs off on those laws. Now included in those laws are the abilities to make regulations under those laws. And so the regulatory process is where the law meets the reality of what people are actually facing on the ground. So if a legislation allows you to make a regulatory process, what that means is that regulations provide support to new laws, and those are enforceable as laws. Now those are typically signed perhaps by the governor and council, it could be signed by a minister, but it's a process by which you don't have to keep going back to the legislature. You simply use the regulatory process to enforce a change or an addition or a modification of what's already permitted through a certain act that impacts Canadians. Now, in my opinion, ultimately our submission here today, or my submission, is that this process is ideal for implementing the necessary acceptance that we need of Sikh articles of faith in various forms. And the reason for that is clear. Legislation sets the standard, whatever legislation that may be, and then regulations are the ones that do the precision work, where eligibility criteria is anchored in faith practice, dignity-respecting documentation, and enforcement guidelines. Ultimately, legislation says, we recognize you, and regulations answers, here's how that recognition will work when it comes to, for example, transit officers, correctional facilities, workplaces, airports, and classrooms. That is the unique mechanism that I believe needs to be implemented when addressing these issues. Now, we talked about the RCMP issue earlier today. Sat also gave a very detailed description of the challenge that took place with the changes made to the RCMP code. Now remember, the unique thing about that is that it wasn't a Sikh who had to go to court to challenge the rules. The rules were accommodated, the rules were accepted to change. There was political leadership to do so with community support. And then somebody from outside of the community challenged that and was not successful. That's a very unique distinction that's important to demonstrate why we need to move in this path as opposed to more of a reactive path through litigation. And so ultimately, the fact that the politicians and the leadership at that time through community engagement stood up in that manner indicated a change in practice, but also a change of perception in how Canadians viewed the issue at all. And so without that, I think it would have been a much more difficult, perhaps, battle to have that same uniform changes necessarily made. The RCMP, the changes have been stood for decades. There's no indication that they're ever going to be changed, but it was a very important, unique experience that I think the Sikhs faced very early, in the 90s. In fact, I want to point here to statements made by the Prime Minister, Brian Mulroney, the Solicitor General, Keir Cadeau, who essentially stood up for a multicultural society to justify why such a change must be made to the regulations of the RCMP rules, and despite the challenges and despite the opposition they were facing. Now, I want to give a Sikh perspective to this issue as well. In this writing, it's a short excerpt from a publication called A Sikh Speaks, which was in the context of this RCMP issue. But I would suggest that it also continues to apply today in many ways to the issues that we're here to talk about and the issues that we're continuing to face. So, in Sadantar Singh, he wrote on the RCMP issue, but as I said, it applies today as well. He writes, in Canada, a multicultural, multiracial, multi-religious society, Sikhs are being asked to dole the turban, disregard the beard, drift along with Western culture, and forget their beliefs and practices in favor of the host culture. In it lies a genuine threat to the moral standards of the Sikh community. It is a cleavage based on race and an affront to the dignity of Sikhs as a people. A person's material possessions may not be worth his or her life, but convictions and dignity are, and a struggle for their upkeep is appreciable. Inaction is a signpost of insubordination, insubordinality of character. The Sikhs, like other ethnic groups, want their cultural autonomy and ethnicity to be maintained and not submerged in the vast cultural ocean of contemporary North America. Now, I want to very briefly touch on the issues of the workplace, but before I do that, I've neglected to mention one thing about the motorcycle issue. Obviously, there's other provinces in Canada where such an exemption has not yet been enacted, but I know that the Sikh Motorcycle Club, many other community organizations are working actively with other provinces to get that same recognition across Canada. What's interesting is, and I've traveled to North Nova Scotia, I've traveled to Yukon with these groups to speak to the legislators there. The unique implication there is that currently their highway traffic acts do not allow for the minister to sign a regulation to bring them in line with Ontario, British Columbia, Manitoba, or other jurisdictions. But what their focus is instead of challenging the community on why such an exemption is necessary, they are amending their Highway Traffic Act for various other reasons, but this is one of them, to allow them to enact regulations. And the feedback that we've received from them is once that Highway Traffic Act receives royal assent, such a regulation to bring it in line seems to be something they can very easily do. So a very unique change in the way in which these issues have been addressed, and a very unique way to demonstrate how the Highway Traffic Act and the legislation has to allow for such regulations to be signed in the first place, which currently Yukon and Nova Scotia are working towards. So very briefly, if we were to make a picture, AI did this, I didn't do this, so don't be too impressed. But it's the difference between legislation versus litigation, a clear comparison. Litigation, as we've seen, there can be a limited scope, it can be unpredictable. I'm a commercial litigation lawyer. I go to court almost every week. I deal with court matters on a daily basis. Any lawyer worth their salt, if they tell you they can guarantee an outcome in a courtroom, is not a good lawyer in my personal opinion. You will have strengths, you will have weaknesses, you will have things you will be able to persuade, and some you may not. There will be an inherent difficulty whenever you get inside of a courtroom. As much as you can avoid that to maintain control on your situation, it's always a good litigation strategy as much as possible. It's not always possible, but sometimes it is. And in issues like this, I believe it is possible. If we focus more towards on legislation, it gives us control to have a broader scope, predictable rules, durable, lasting outcomes, and more of a consensus-based community approach on issues, as opposed to just one individual, isolated, case-by-case, ad hoc basis of dealing with disputes. And in conclusion, just one final remark. As I mentioned, the workplace. I know a lot of Gurdwaras are working with the Ontario government for the purpose of enacting or having some sort of workplace regulations proposed that would address issues faced, for example, by truck drivers when they go to a yard simply to drop off a load, or other sort of issues like that. Through the Gurdwaras, the Interior Gurdwaras Committee, we've suggested, in fact, a draft regulation that could be included in the Occupational Health and Safety Act that mimics the type of regulation that we already have in Ontario with the Highway Traffic Act, but applies specifically perhaps to individuals who are truck drivers, licensed to be truck drivers, and are simply going to various workplaces and yards across Ontario. And so we're hopeful that the government will also work towards that. Just in conclusion, I'll finally conclude with these few comments to at least wrap up what I think is the ultimate ethos of what we're trying to say in this conference, is that dignity worn openly strengthens our common life. We should write our laws to reflect what we already know, that any dignity, anything that gives an individual dignity, when it is worn openly and it strengthens them as an individual, it in fact strengthens our community, our common life, rather than fracture us. Thank you very much.
Thank you, Vikram. We're going to move forward with our last speaker. Our final presenter is Balpreet Singh Bhuprai, Legal Counsel for the World Sikh Organization of Canada since 2009. Balpreet has resolved some of the most significant accommodation cases for Sikhs across the country, from Gurban access in courthouses to protections on VI Rail and in Canadian embassies internationally. He is the WSO's national spokesperson and one of the most trusted voices on Sikh rights in Canada. Please welcome Balpreet Singh Bhuprai.
Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh. So thank you for having me. I'm going to start by giving us a little bit of an overview of where we are in terms of the country, the Sikh community, because we're living in interesting times, I would say. And interesting times not in necessarily the best way. I'm going to do a bit of a plug. For the past year, we have been doing a study on anti-Sikh hate in Canada. We've been going across the country and we've had approximately 2,000 surveys. And the results are very alarming in terms of where the Sikh community is reporting discrimination, hatred, a negative sentiment across the country, I would suggest. We will be launching this report on April 18th. We will be having the event, I believe, here. It's going to be an interesting panel. It's going to be three trailblazers, Baltesh Singh Dhillon, Gurbaz Singh Multani, who had the monumental Kirpan case, and Jagmeet Singh. So three, I would say, historical figures in our community who will be talking about their experiences and their understanding of anti-Sikh hate. But also I would point out to you that this past week, WSO's legal team was at the Supreme Court of Canada fighting Bill 21 as an appellant. And this case is going to be fundamental to how we understand freedom of religion in Canada. So if a government is allowed to say that our citizens cannot wear dastars or hijabs, and we're going to insulate that using the notwithstanding clause, then the question that was asked of the court was that what's the content of freedom of religion? So if a government can suspend these rights for 5 years at a time and keep renewing that suspension, then what really does freedom of religion mean in Canada? And the answer is not very much. So today, we're seeing in Quebec in 2019, this law was passed, and the effects on the ground are actually tragic. Sikh bus drivers, who for years wore the stars, today are wearing baseball caps. And even though this law doesn't apply to them, they're saying our employer expects us not to wear the star, and we don't have the ability to challenge that. When I was there in November, most recently, I had a mother come to me and say, I understand Bill 21 is now being expanded, and it has been expanded now. And she said, does that mean I can't go help as a volunteer at my kids' school for lunch? And the answer was yes, you can't go anymore. And now, the PQ, who's leading in the polls in Quebec for the upcoming election in November, have said that as a part of their policy mandate, they will increase the scope of Bill 21 so that Sikh children, any children, students, cannot wear articles of faith or so-called religious symbols. So now, if our kids cannot wear their partke and their dastars and their keskis to school anymore, do we have a place in Quebec? Do we have a place in this country if other provinces start to expand Bill 21 or adopt it? And I will point out to you that the largest support for Bill 21 anywhere in Canada outside of Quebec is in Alberta. And Alberta has now declared a referendum on immigrants. And the sentiment there is similar to what we saw earlier in Quebec. So if this expands and the court isn't able to do anything, then where does that leave us? It's a very scary prospect. And I don't think we necessarily understand it fully. But I can tell you my perspective is from the ground, so a view from the trenches, as it were. So I can tell you just from the past week the issues that I've been dealing with. I had a Sikh nurse tell me at a downtown hospital that she's not able to wear her kara because they say nothing below the sleeves, but other faiths are able to wear long sleeves, so I'm able to help her out. BC Ferries. BC Ferries is a large employer who had declared that non-bearded people, so clean-shaven, can apply for their jobs. People with beards cannot. And in order to so-called accommodate, they offered this to some Sikh workers who tragically accepted some of them have held out. It was that once a year, you will appear clean-shaven for a fit test, and then for the rest of the year, you can keep your beard. I mean, what is this fiction? That for once a year, you're forcing someone to betray their own faith, and then for the rest of the year, we'll turn a blind eye to it. It serves no practical function. But I'm happy to say that after months, if not years of advocacy, this past week, BC Ferries announced that for about 3/4 of their jobs, they have removed the clean-shaven requirement. So these things are happening on the ground. I'll give you a last one. There was a gym in London, Ontario, 2 weeks ago, who saw a kirpan-wearing patron and declared that his membership was cancelled. You cannot wear a weapon in our gym. And then back and forth with them to get a policy to accommodate the kirpan. So they came back to me, well, okay, maybe you can do it while lifting weights, but not in the change room, not while swimming. So, I mean, this is happening today, and the law is very clear. You have to accommodate the kirpan. There's only 2 places in Canada today where you cannot accommodate the kirpan, where the kirpan cannot be worn. Prison and the Quebec National Assembly. And the Quebec National Assembly is a very special place. They've got some interesting things happening there. But this is where I'm going to come to you from my perspective. I'm going to give you another case, actually. This was 2020. So 6 years ago. It was a Sikh worker at a factory. He was an international student. And someone walked up to my manager and said, "Are you wearing a knife?" And his kirpan was underneath his clothing. And he said, "I'm wearing a kirpan." And he said, "We have told the agency that sent you not to send people like you because we don't want people wearing knives here." The audacity of it. We filed that case in 2020. In 2020 we filed it, and you'll be surprised to know that that case has gone through 3 mediations and was set to be heard in March of this year, but the lawyer on the other side said that she's not available anymore. So now it's set for June. So 6 years for a Sikh factory worker to come before a tribunal to say the obvious, which is I'm allowed to wear my kirpan, and to have the tribunal rubber stamp it, which they will do it. But who can wait 6 years? And at this point, he doesn't even care anymore. He's moved on. It's irrelevant to him. He's fighting it for the principle of it. But who has time to wait for 6 years for a tribunal or a court to pronounce something on what is an obvious facet of the law? And that's what brings me to my topic today, which is beyond the courtroom, strategic alternatives to litigation. So I started with this, which is the timelines in court cases are just unfortunate. If you bring something into a court system or a tribunal system, you will be sitting there for years. And if it's been already litigated, and you're just waiting for someone to rubber stamp it that yes, you can't do this. Even employers actually are starting to see this, that they're saying, take it to the tribunal, we'll deal with it. It's going to take years for you to get there anyways. They don't care. So if there's a clear solution, you know the law is clear on it, then there are better alternatives to litigation. And that, my friends, is public attention, media. You blow things up, is what we call it at WSO. So, if we see someone that is a good character, so I'm speaking very frankly with you. If you have someone that is a legitimate, good faith actor that has had an injustice, then that's the first ingredient for a public blow-up, for a media case. So I'll give you another example. You have to pick the case. You have to pick the person bringing the case. Not every person comes to a case with clean hands. For example, the kirpan case that resulted in the ban or the prohibition of the kirpan in courthouses was something called R versus OT. It was a 1985 case. It was 5 Sikhs who were charged with assault. This was, I believe, connected to a protest against the Indian High Commissioner. But they wanted to wear the kirpan into the courthouse. But the judge is looking at accused individuals wanting to wear a knife inside a courthouse. And they're, once again, accused of assault. So that didn't go the right way. This was one of the first cases I took on in 2009 when I became legal counsel for WSO. We had a young woman at the York University social work program who was denied entry into Osgoode Hall courthouses. This was ideal. So it's a young woman, a student, and who's going there as a part of her classwork. And we took that all the way through. We didn't actually throw media attention on it. But as a result, that court case, that tribunal case, resulted in the accommodation that we've now been able to get across the country. So it was the right person. So for the media strategy, you also have to find the right person. Is this person people can sympathize with? Is it an issue that people can sympathize with? And I'll tell you, generally, the kirpan is not the best for these things. Explaining the significance of the kirpan is very difficult for someone at first glance. You can do it if you have a little bit of time, but most people are looking at headlines and pictures. So the other thing is, what's the urgency? You need a quick fix. for the community or for this individual? And what's the broader community interest? Will the community get behind you? So overall, when we have an issue that is urgent, clear, and publicly compelling, and the law is clear on it, then that's what we take to the media. And we get pretty quick results. So let's go through a few examples. In 2015, this was under the Conservative government, right before the 2015 election, CATSA brought in a rule that anyone that wears a dastard will have to go through secondary screening, which means explosive testing. So every single time where someone is going through airport security and they have a dastard, the rule was brought in that they will have to touch their dastard and be tested for explosive residue. Completely ridiculous. Why would you want to do this to every single Sikh? If they're not alarming. If they're alarming, it's a different story. And when we asked, they said, well, you know, it's a bulky piece of clothing and you never know, something could be hidden there. And my answer was, I've heard of shoe bombers, I've heard of underwear bombers, but when was the last time you heard about a turban bomber? I said, are you going to require everyone wearing underwear to touch their underwear and have that scanned as well? And the answer was, well, you know, that's true, and think about it. But we worked on that behind the scenes for months. So April to June. And we had this frequent traveler. And let me give you a little bit of insight into who this was. So today, Bhupinder Kundal is Global Television, BC, the news producer. His younger brother. So someone who's familiar with the media and someone who's traveling on literally a weekly basis. And he's got clearance, supposed to be in the fast track. So when we realized this issue is not going anywhere behind the scenes, and we realized there's an election coming up, and we've got a guy who can speak good English, and he's got a compelling story, we put it into the media, and the result was instantaneous. So the next day, the same day we put it into the media, the government backtracked saying, no, we will get this fixed. That Sikhs will not have to have this done. And to this day, that practice has stood. So that for us was a good example of don't fight this behind the scenes or take it to a tribunal. Put it in front of the media. And sometimes you get very quick results. Same day. Here's another one. We try and do this in good faith. We try and give people the opportunity, organizations the opportunity to fix things. So COVID comes around, and at first instance, every single police force in Canada took their bearded workers, bearded police officers, and put them on office duty, desk duty. Every single police force. But within weeks, all the other police forces got it, that the vast majority of police officers will not need to have a tight-fitting N95. You only need an N95 where there's an aerosol-generating medical procedure, like someone's being intubated. For everyone else, a simple mask that's covering your face will be more than enough. All the other police forces got it. The RCMP stuck to their guns. So for months, so we're talking March until October, we are advocating on behalf of this large cohort of Sikh RCMP officers who are sitting on desk duty. And there's sometimes security in numbers. No individual officer wanted to come forward and say, this is about me. Because they were afraid that there might be problems in their career, they might get blowback from their superiors. But as a cohort, as a group, there's safety in numbers. So once again, we worked, we sent letter after letter to the commissioner, no proper response. We put it into the media, and Prime Minister Trudeau stood up in Parliament and said, this isn't right, that this shouldn't have happened. So September 24th, we put out that press release, and by October 1st, the RCMP put those officers back on duty. It worked. So this was compelling. These are Sikh RCMP officers, and every other police force is already saying, yeah, you can go back to work. So what's special about these RCMP officers? It made sense. But we short-circuited the system. We didn't have to go through the courts. We didn't have to go through the tribunals. We did it in the media. One more example. Toronto security guards. over 100 Sikh security guards working at Toronto facilities, City of Toronto facilities, were laid off. So they worked throughout COVID without any N95 requirement. But when the pandemic was it's basically on its low side, now there's so many more N95 masks that are available. So now that there's more masks available, they decide we're going to require everyone to be fitted and you've got to be clean shaven. And if you're not clean shaven, off the job. And these are international students. So they just want to work. They don't want to cause any problems. They just want to go back to work. And they said, how is it fair that we worked through the pandemic when it was the most dangerous? And now when the pandemic's over, now they've decided that we need to all be clean shaven because we can't be fitted with an N95. Once again, we tried to solve this behind the scenes. Tried to speak sense to the security officers, sent letters to the City of Toronto. But when we put it into the media, I can tell you, John Tory called me the same day. I don't know where he got my number from, probably from the press release or something. And he said, this was wrong, and we'll get this fixed. Back to the job, with compensation, and the assurance that they will be accommodated moving forward. Literally the same day. And this is probably the latest one. This isn't actually the only shaving incident that has come to our attention. We've had a baby whose head was shaved, an Amritdhari couple's baby whose head was shaved. We've had an elderly gentleman in British Columbia whose beard was shaved. He actually stopped eating and he died. This was someone who was vulnerable. This was someone who didn't deserve this. There was no medical reason for him to be shaved. And we had worked with Osler in good faith, not on this case. We had worked with Osler through the pandemic on issues dealing with sick patients who were not treated properly. I'll give you one COVID example. This was an Amritdhari patient during COVID, and he was in the intensive care unit. We said that his family wants him to have his kakas, his articles of faith, with him. The family said the nurses aren't listening. I called the head nurse and I said, these are articles of faith. There's no reason why he can't have them on his person. She said, we got lots of articles of faith. We'll try and place it around the room, but we can't be doing this for special care needs like this. It's not going to work. But they don't even know what I'm talking about. They're saying they're going to put the articles of faith around the room. Like, what are you even talking about? And so rude. We tried to work with Osler. We did not get the result we wanted. So when this case came to us, we didn't wait. The family was willing to go to the media. The elderly gentleman was, of course, not able to give his consent, but the family was willing to do it. And when we put that in, this was something that shocked the conscience of the community, because the community are big supporters of Osler. But Osler realized they had screwed up big time. And the result has been that they brought in Sikh training, Sikh resources. It's been an institutional change that they are now treating Sikh patients with the care and respect and with the knowledge that they deserve. But this wasn't, once again, through litigation. This was through blowing this up in the media. So here are my thoughts. If you have a case that is clear, the law is decided, and you have clear objectives, then you may not want to wait to take things into a court or to a tribunal. You may want to do this in the public forum. This doesn't necessarily always work. You have to be careful. And I'll give you my example to finish it. So this isn't a fail-safe strategy. My first introduction to the law was law school, first year law school. I was thrown off a Via Rail train going from Toronto to Ottawa. And they said, we don't know what to do about the Durban. And they put me back on the next one in first class, and they said, well, that's okay, you can go in first class to make up for the missed train, and we'll figure it out. 2 weeks later, when I was coming back from Ottawa to Toronto, same thing happened. They pulled me off the train, security pulled me off, and they said, we've decided to no Gurbans. One of my classmates in law school said, my father is a journalist, you should take this to him. So I took it to him, he did the story, and they sent a photographer. And I remember I was wearing a Gurban. It wasn't the Gurban that for my second journey I was wearing. It was a larger Gurban, but it wasn't, a thin footy or something. But the journalist, the photographer goes, can I take a picture of the Quran? I go, it's not really the point, it's not the same Quran. And he goes, well, all right, can I just take a look at this angle? I'm just going to take this angle. The angle he took made the Quran I was wearing look huge. And they put it on the front page of the city section. And the result was that the average person seeing this picture was like, I don't want this guy wearing this beside me. And it was a net negative. I had classmates coming up to me saying, you're a good guy, but I don't think you should be able to wear that. It was a disaster. I won that case because the ironic thing was that in the first class box that they put me, to make up for things, I wasn't the guy with a knife. Everyone got a steak knife for their meal. So everyone gets a knife, and that's not a problem. But my knife is the problem. So we won that case easily, but that taught me that not every story will work in the media. You gotta pick the ones that will work, and sometimes you will get a very quick result. So I'll leave it there. Thank you very much.
Thank you to all the speakers. We'll open it up for discussion and questions. And actually, I'll ask if the speakers can come back on stage. And I'll have a mic to go around to ask any questions or comments anybody has. Oh, that'll take around. So this will be for you guys. Any questions? Yes.
Thank you for all the work that you guys all do. I know it's exhausting even having the conversations today. And it seems like all this time that we've been part of the diaspora, the Canadian diaspora, that it seems like it's always a new fight. And definitely it feels like everything is happening in silos. My comment on, or just a conversation with you on this, or question on this is how do we actually resolve this? Aside from looking at it from those different perspectives, where is that you see the Sikh Motorcycle Club, for example, advocating through more of a policy-based, so with reference to actual elected officials and going through work in that case. And in other cases where we can use media to bring attention to these issues, aside from the courts themselves making decisions, and it seems like the courts are making decisions, although they should be broad, they're being seen actually to be particular to the case itself. In all of those cases, it seems like we're still losing that battle every single time. Everybody feels like they're in a silo to deal with the issues. An example of the Sikh Motorcycle Club, aside from the fact that we have an exemption in Ontario, one of the things that now is starting to occur is the actual schools that teach motorcycling are gatekeeping. So meaning that they are not allowing Sikhs to actually ride without a turban, or without a helmet rather, because they can't get licensed now. So this is the gatekeeping that's happening on the private sector side. So the private organizations that are saying that the insurance policies are not, they don't cover them and whatnot. So that's the other part of that story, just to understand that. But my question on this is that what you think is the way to go about this in general terms is, should it actually have an enforcement aspect to violating somebody's rights in Canada and in Ontario specifically?
My quick observation is that you don't wake up and say, okay, I can take it easy because human rights are respected and observed. Every day you've got to be vigilant. I think Rupeet's given examples of that. So It's one thing to have the legislation, it's another thing with respect to that legislation being respected. I know I was involved in the Bond case back in 1990, even though we had a positive decision, there were thousands of people upset in Peel, in mine and other parts of Ontario. My quick suggestion, it's just sheer numbers. It's just going to different organizations and educating. I'm not current with social media these days. I'm sure there are tools to do that. It's a tough task. It needs committed people to be part of your organization. I'll just give you a quick example of my own experience. I was privileged to be a member of the Peel Regional Police Board for 3 years, 2007 to 2010. And this is, I'm going to digress a little bit, but I'll give you an example of what you come across. The very first instance, well, first of all, on my bio when I was introduced to the Peel Police Force seniors, they didn't mention the fact that I was a senior commercial lawyer, that I'd written in books on, say, condominium law. They mentioned that I was an anti-racist advocate, so right away, there was X's all over against me, and I knew I was targeted. So I made a point, every board meeting, on commenting on everything other than, or in addition to civil rights matters, I had to do that much extra work. But here's the point I want to make. I asked from day one a copy of the ethnocultural policy, as it was called, at the Regional Appeal. I asked the executive director for that. I had a 3-year term, I got it in my 3rd year. Now, before that point, I sat aside with the executive director, and because basically that person really controls the agenda, and I sat with the chair of the Peel Police Board, and I said, hey guys, I'm not happy with how we're implementing EDI, diversity. I look around the top 40 people in your organization, only one reflects a diverse community. There's something wrong, and I got all kinds of silly reasons as to why, people in your community don't want to be members of the police force. Then tell them that 85% of the police don't pull a gun in a year. Give them reasons, go out to them to recruit them. But more practically, I represent a lot of business clients. We have business plans. Give me your plan whereby you will reach the targets such that members of the senior police reflect the community. And we need champions to make sure that that policy is advocated within the organization. And I got resistance, and finally after my 3 years were up, I decided I had enough. But you need to have champions in senior organizations. You need to work with them, educate them, help them go through the system. I apologize for long answer. I'm not sure if I came up with any suggestions, but with observations.
Just one final comment. I mean, in the specific example you've given about potential gatekeeping or issues where others in, let's say, the motorcycle community or the motorcycle world, there's issues you're facing despite the exemption. To Sat's point as well is that perhaps more of a focus as an institution, and it applies to all of us, but more specifically to, let's say, the motorcycle club, is making inroads with schools, or I know you guys, we go to the motorcycle show every year. So making those inroads outside of our community over time, I think, will definitely assist in addressing some of those issues, in my view.
First, I would like to congratulate the organizers for this seminar and all the speakers. I'm sorry I missed the first couple of you presentation, but still it was very meaningful and good. I have got 3 points. The first is a question to all of you. The question is that it is absolutely true we have been all of us here a long time, and these issues are still there, right? So the first one is, as you said it very well, that in order to deal with these issues and address these ones in a good way, effective way, there are both ways required, reactive and proactive move, right? Reactive is when we are fighting with this one here and there, which you guys are doing good job. But proactive, do you have any plan for the community organizations, the people who are representing us, including good for ourselves and everybody, so that we can take this one in a more meaningful and productive way? My second question is to all of us, including myself. We must act as the eyes and ears for our politicians. I was honestly surprised, unpleasantly, I'm sorry to use this word, when Ruby Sohota, she stood up, sorry, my daughter, and you are not able to give us any concrete plan over here. We do expect something from you. You have big responsibility on your shoulders. I'm not trying to criticize, but I'm sharing my thoughts with you. Because we have big hopes from all our elected officials at every level, federal, provincial, and municipality too. My third is that all of us, as I said to all of you, that we must act as eyes and ears without any fear to give the feedback to these people who has been elected by you. That you are doing very good. Keep on doing it so that it will be encouragement to them and they will keep on further improving it. It is not criticism again, I'm sorry using the word. It is that people they say there is always a room for improvement. We have seen, I worked with OPG, I worked with Ontario Hydro various companies. It is true, articles of faith and urban. These people sometimes they make issue without any reason, no justification at all. So we need to act more on this one. Again, my sincere thanks to Mr. Paul and whoever the other organizers are. I think that we need to continue with this one more progressively so that we can make it more effective and useful. Thank you.
Thank you. If I can just add one comment, and I'll give the microphone to my friends here as well. Look, I agree with you 100%. I think my presentation was quite clear that in our view, legislators, elected officials, they are duty-bound to address these issues. I certainly agree with that. But I will say, it's also a two-way street for all of us, right, included. Is in order for us to have politicians or elected representatives address the things we need, the community also has to actively engage and address issues in a meaningful manner with them. It can't just be something that happens automatically. So events like this, other organizations and groups doing these types of initiatives obviously lead towards hopefully being a reality.
Thanks, Vikram. All I can really say is that we need to have people in the community trained to present a particular presentation of the Sikhs that we can all accept. That means educating and providing scholarships for your journalists, for your law students, for people who, by their profession, are very good at articulating and presenting our viewpoint across. We've lost 30 years by not having shares of Sikh studies for all kinds of reasons that I think really we shouldn't have gone through those. If we could have had a chair of Sikh studies that focused on multimedia years ago, I think there would have been a tremendous advance in terms of presenting our message. I'm not saying it to be on the end all, but it's just my observation. We've got this chance now, let's not blow that chance. So those are the kind of people that we need to make sure that represent us, that we need to nurture. The good thing is that they're coming great droves right now. I see your poets, your artists, people who are trained to present viewpoints that are not acceptable in an acceptable fashion. They're coming through. It's your philosophers that at the end of the day are going to be able to advance these kind of arguments, these kind of images that we want. And I know it sounds a little idealistic, but if you look at any society that grew to the point where it could make a significant change in people's mindsets, those are the kind of people you need.
Just to add, as I mentioned in my presentation, to the onus of acknowledging the accommodation needs to be on the shoulders of the institution and the politicians. And as you said, that there are expectations from the politicians and proactive expectations. And I think that's where we need to hold our politicians to. And conferences such like we are doing today, so this is a work in progress. So these conferences, these kind of discussions help move community forward, engage the politicians, engage the institutions, other government departments, may it be federal, provincial, or city. It's a work in progress. It's going to take, I think we have come a long way. If we look back in the last 40 years or so, from 70s till now, we have come a long way, but there's a long way, long journey ahead of us still. Your concern, your question is great, and I think this is a work in progress, and we need to find a mechanism to put this onus back on the employers proactively, and I think engaging politicians is the best way, and I think we are doing that today, and this message will go somewhere hopefully, and then we can see something in future coming up. That's the hope.
So I'm going to say something nice about Ruby, which is that I can say that whenever Ruby comes to a community event, she actually sticks around and listens. So that for me is significant. So I'm going to say two things. One, the role of gurdwaras and community organizations. I'm going to give you an example that's not from Ontario. Okay, not from Ontario. It happened recently in another province. So an attorney general of a province came to visit a gurdwara, and I had a young person who sat in on the meeting but wasn't able to speak. And the Attorney General asked, what are the issues that you want us to take up for you? And the issue that was brought up was that at our Nagar Kirtan, the ambulance cost has increased to almost triple what it used to be, and we need the ambulance cost to come down. And the Attorney General said, well, you should take that up with the city, and you can mention that I agree with you. And that was it. She had, the Attorney General had cha and left. The number of issues we could have brought up was numerous. It could have been foreign interference, it could have been extortions, it could have been around law reform, around accommodations, and we have to bring in the people that have these, have the ability to advocate on behalf of our community into these spaces. It's not a question about, we'll lose our leadership or something like that. And I see really great work happening. So some gurdwaras are doing really amazing work. So the Guru Nanak Center here, who held our Mission Center, have brought this conference together. That's amazing work. But we need to advocate on a stronger level. And I'm going to go through just a couple of the issues that I think governments can help with. We've been asking the federal government to give us an accommodation for Sikh truck drivers going to ports for the past 11 years. So 2015, I got my brief that I took to Ottawa in 2015 saying that this should happen. So the Quebec court has ruled that no, you don't need to accommodate. But on a practical level, we resolved this with the Hamilton ports, and they've been accommodating for the past, it was pre-COVID when we did this. I don't remember the exact year. So it's not only possible, it's happening. And this could be fixed at the federal level. So that's hard hats. We've done something with BC. For example, WorkSafe BC regulations have been updated to say that you can't bring in umbrella hard hat requirements. You have to show that you used every step before that. You have to show administrative controls. You have to show actual physical controls. If you put in a net or something like that. And only as a last resort, it's in the regulations. Can you bring in a hard hat policy that's across the board? So addressing this is the first. And the second is beards and respirators. This is something that the work is already happening. So we've been working with the Ontario government on a study on the Sikh method. It's close to the finish line. So we still, if you check our social media, we still need volunteers. We needed 200 tests to be done. I think we're at 175 or something. And if that Sikh method, and it's already looking very promising, if that is adopted, we're going to have to bring in regulation changes across the country, et cetera, et cetera. But that means no one can ever say to our community, you need to be clean shaven. And that's a huge win. But we will need government help to get those regulations updated in a quick manner. Because, I mean, if you let these things follow their course through the red tape, it takes years and years and years. So when it comes to accommodations, hard hats and beards are something that everyone should be asking, what are you doing? And I'll finish with this. When I meet with our politicians, or any politicians, whether I'm bringing up Indian transnational oppression, or I'm bringing up accommodation issues, or back in the day when I was bringing up Afghanistan refugee issues, the same thing I hear from them is that we go into the community and no one talks to us about this. You're the only one that talks to us about this. No one cares. And I know that's not true. Our community cares. But sometimes we're not the best at expressing that care, expressing the need for these things. So we've got to be better advocates, and I think the government has to act on it as well. These things have been in front of them for many, many years.
मैंने पता है सारा कॉन्फ्रेंस अंग्रेजी में किया सो जे कोई पंजाबी में सवाल पूछना चाह रहा है या अपने कोई विचार शेयर करना चाह रहे हैं please feel comfortable.
Thank you. Waheguru Ji for Council, Waheguru Ji for Vic. My name is Prabh Singh. I'm legal advisor for World Sikh Parliament. I'm also a family and commercial arbitrator. So I'll try to speak in Punjabi. I believe the speaker, Mr. you spoke about social impact, and I'd like to share my example. I have an impact. So what we have seen as people Punjabi, ਅਸੀਂ ਕੀ ਦੇਖਿਆ ਹੈ ਕਿ ਜਿਹੜੇ ਕਕਾਰਧਾਰੀ, ਅਮਰਧਾਰੀ activists, Sikh activists, and ਖਾਸ ਕਰਕੇ business or entrepreneurs, they end up losing business within the community. Okay? The question we have seen that just on if this person is advocating for Sikh rights only. When a Muslim talks about Islamophobia, that is fair. You look at Kala, black rights, which is fair. I work with indigenous a lot because I'm in London, and there's no issue. But it's Sikh, that Sikh is considered as a radical. So, what we came to the conclusion, we did a survey, that ਜੇ ਕੋਈ ਸਹਿਜਪਾਈ Sikh, human rights it's more acceptable within the community rather than a person like me or even Bobby. How individuals like specifically Bobby were blessed to have such individual, because if you work within an organization, right, in-house, versus running your own business is a big challenge, right? I just wanted to put it out there. Dujigala, I'd like to mention that we're talking about issues within Canada. What we learned over time that internal racism that I lived in a rural area all my life, Windsor, London, Chatham. People like to deal with Sikhs professionally. Why is that? A Sikh brings in Sikh values, human values, legal practice, professionalism. They appreciate it. What we did, we introduced media and PD in our practice. And I tell you, community loves it. Mainstream community doesn't have to be a Sikh community. But the things we have seen that what is impacting Sikh community nowadays is transnational oppression. We are in a narrative crisis. You talk about media. So I give you a prime example and I'll conclude it. Woodstock, last year we had a session about human rights. We commemorated Arjun Pasha Shahidi Divas, right? Ote Goraya, and he literally ran into the hall. Ote Guru Sabda Prakasiga. Luckily we stopped. Right? Only Jado Sikh Richard Dekhe, Nishan Sab Dekhe. And he goes, these are radical flags. These are flags for terrorist groups. I'm like, what are you talking about? He goes, oh, weren't you not the one in front of a Hindu mandir protesting? You see what I mean? And you all know that this is a product of transnational oppression, creating fear, creating identity crisis among, and something what when we hear these serious issues. So I really want to touch these issues with you folks. Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh.
I can comment on it a little bit.